Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. Today we're going to talk about Carrington's case and what he's going to be filing soon. You can find my Facebook page, Foreclosure Help 777, or you can send me an email at my email address, which is foreclosurehelp777@gmail.com. And it is spelled with the number 4, guys. And as always, I am not an attorney and I do not give legal advice. This is strictly for entertainment purposes only, guys. So let's go through the next thing we're going to talk about, and that's Carrington's next motion. He's going to basically file a motion to challenge authority to represent. Let's talk about this. Comes now, defendant William Carrington, pro se, and hereby files this motion to challenge authority to represent as follows. In the background it says, on May 7, 2009, the plaintiff, through the law firm Fine Such and Crane, LLP, filed a foreclosure complaint identifying itself as the plaintiff, Wells Fargo Bank, N.A., as trustee for the certificate holders of Soundview Home Loan Trust, 2007 OPT1, Asset-Backed Certificate Series, 2007 OPT1. Historical context. From May 7, 2009 until August 6, 2024, defendant did not question the plaintiff's status despite 15 years of ongoing litigation. FOIA requests. Alright, on August the 6th, 2024, defendant submitted a FOIA request, which is Freedom of Information Act request, via email. The FOIA's email address to the SEC is foiapa@sec.gov. To the Securities and Exchange, hereinafter SEC. A copy of this email is attached hereto as Exhibit A, SEC Inquiry. This email requested inter alia, which means, among other things, records pertaining to the cessation of operations of the Soundview Home Loan Trust, 2007 OPT1. On August 7, 2024, defendant received an email acknowledgement from the SEC with a tracking number, and there's a tracking number. A copy of this acknowledgement email is attached hereto as Exhibit B, SEC response. Defendant received a response from the SEC on, there's a date there because we haven't gotten that one back quite yet. A copy of this response is hereto attached as Exhibit C. We know already ahead of time what the response is going to be, which is why we made this ahead of time, guys. Trust status. The SEC's response, as we know, indicated that the trust ceased operations on January 28, 2008, and provided a link for further information. Verification. Defendant verified this information, including Form 15D signed by Thomas J. Conway, Senior Vice President, which is attached as Exhibit D. Now there's a footnote here that says the SEC Form 15D is a certification of termination of registration of a class of security under Section 12G, or a notice of suspension of duty to file reports pursuant to Section 13 and 15D of the 1934 Securities Exchange Act. Implications. The FOIA request and Form 15D confirm that plaintiff, Wells Fargo N.A., as trustee for the Soundview Home Loan Trust, ceased operations on January 28, 2008. Therefore, the plaintiff did not exist at the time the complaint was filed on May 7, 2009. Lack of authority. The plaintiff's attorney lacks authority to represent a non-existent entity. Potential fraud. The continued representation by the plaintiff's attorney suggests a potential fraud or misrepresentation. Questions for the court. Who is the attorney truly representing? Does the attorney have the authority to represent a non-existent entity? Is the attorney perpetuating a fraud or misrepresentation? is an imposter using the trust name to pursue this lawsuit without a legitimate authority. And the big thing here, the big takeaway, is plaintiff lacks subject matter jurisdiction. Legal precedent. To have jurisdiction, a plaintiff must exist. See IndyMac FSB versus Mendel Measles, and the case number is there. It's also in Brooklyn, where Carrington's case is. In this case, the court determined that it was an extraordinary circumstance for a non-existent corporate entity to retain counsel and proceed with foreclosure. As a result, the court vacated the default. It was a default judgment, dismissed the action with prejudice, and considered sanctions for frivolous conduct. And as you can see, there is a footnote on the previous page about this case that says this court grants relief to defendant Measles in this instant action. Plaintiff IndyMac Fed lacks jurisdiction. It ceased to exist on March 19, 2009, almost 3 weeks before the instant action commenced on April 9, 2009. If plaintiff IndyMac Fed has jurisdiction and standing, it would be the legal equivalent of a vampire, the living dead. Further, the court is concerned that there are more documents in this action in which various individuals claim to be officers or either the living dead, IndyMac Fed, or its deceased predecessor, IndyMac Bank FSB, and the law firm of Feinsuch and Crane LLP, commenced and prosecuted this meritless action, asserting false material statements on behalf of a client that ceased to exist 20 days prior to the commencement of this instant action. So let's go on to the next part here. This case, like the IndyMac FSB versus Mendel Measles, was initiated by the same law firm, Feinsuch and Crane. In the IndyMac FSB versus Mendel Measles case, it states, further, the court finds that it is extraordinary circumstance for a corporate entity that ceased to exist, plaintiff IndyMac Fed, to retain counsel and proceed to foreclose on a mortgage for real property. This extraordinary circumstance requires the court to vacate defendant Measles' default because it's impossible for the living dead plaintiff IndyMac Fed to have jurisdiction, dismiss the instant action with prejudice, and give FS&C, which is Feinsuch and Crane, an opportunity to be heard as to why the court should not sanction it for engaging in frivolous conduct in violation of 22 NYCRR 130-1.1c1 and 3, because the instant action is completely without merit in law and asserts material factual representations that are false. Notably, the same attorney, Mark Broyles, initiated both this case and the IndyMac FSB versus Mendel Measles just a month apart, demonstrating a troubling pattern of pursuing foreclosures on behalf of potentially non-existent entities. Conclusion. For the reasons stated above, defendant William Carrington respectfully requests that this court grant this motion and challenge the authority of Ronald Park of Hinshaw and Culbertson to represent the non-existent plaintiff Wells Fargo as trustee for the Soundview Home Loan 2007 OPT1 Trust, dismiss this case for lack of subject matter jurisdiction as the plaintiff lacks standing due to its non-existence, take appropriate action to maintain the integrity and impartiality of the judiciary in light of the substantial violations of the rules of professional conduct suggested by the circumstances of this case. And then he signed here, and then you can see the exhibits, the FOIA case, where he asks, basically on this email, hello, my name is William Carrington. I'm requesting information pursuant to the Freedom of Information Act. I hereby request the following: records pertaining to the cessation of operations of the Soundview Home Loan Trust 2007 OPT1. Records or documents that indicate no new loans can be added to this trust after the closing date, including any policies, procedures, restrictions, or exceptions relevant to this matter. Number 3, if new loans can be added to the trust after the closing date, please provide the expectations or conditions that would allow a loan to enter the trust after the closing date. Number 4, please provide the requested records in electronic format if possible. Thank you for your attention to this matter. I hope you have a good day. And then the next page, Exhibit B, acknowledgement email from the SEC, which basically states Freedom of Information Act, and basically it has a tracking number. It says that they received it and they're going to work on it and then get back to them. I mean, I don't have to read the whole thing. You guys got the gist of it anyway. Exhibit C. We leave this blank because we're waiting for their response, and then we will add it into his motion. Exhibit D is the Form 15. Form 15, which is online. You can find it. Basically, it has the box checked right here, 15D6. And it states at the very bottom the date, January 28, 2008, and it's signed by Thomas J. Conway, who is the Senior Vice President of the Soundview Home Loan Trust. Okay guys, so you pretty much got an idea of what this motion is all about. If you guys do have any other questions or comments, you can leave them and I will try to answer your comments and questions. And as always, we do have these templates for FOIA requests on my website, on the Facebook page. So if you come and join us here, you will be able to access our files, which we share with each other. I hope everyone has a blessed day.